The General has clarified a number of issues. You know, for us in football, when you are passing and you get boys or girls playing football with a good talent, we pick them and take them to football clubs. We don't take them to Malua groups, so that their talents are well developed and handled there. So in a situation, one is carrying a gun to harm others, terrorize others. Berets which are for military. What is the interest of that person? Do you have to waste time with that person? Take that person where he belongs. Take to the court which it belongs. And now, the issues of independence have been clarified here in this bill, which is so good. In case there are going to be any gaps, we are still here. We shall come back and amend those gaps to make it better and better. Laws are built and made better over time. So, Right Honorable Speaker, I would like now to propose that we constitute ourselves to the Committee of the whole House, and then we debate the clauses. Thank you.
Honorable Speaker,
Maybe when a motion, maybe there is a motion. Let's dispose of the motion first. I'll give you. Now I'm going to give you, even when we are at committee, I'll give you special consideration. You can.
Forward.
Yes, I'm going to give you. I am going to give you. Honorable members, I am saying I'm going to give you. Why do you challenge my powers? I am going to give you. Honorable members, this has been seconded by Richard, the Prime Minister, Honorable Bahati, Ajat, Honorable Oboth, Ogwang, Namiango, Gume, by the whole House with the exception of Honorable Odur and Gilbert. Honorable Tafire this morning came to my office and asked for permission. He said he does not have a suit which fits him. Yes, so I gave him permission. Honorable, I'm going to give you to seek for a clarification.
I would like to say what is good for the goose is good to the contrary, even for the gander. What my colleague is talking about is apparent. People are picked up in civilian cars during operations and with people that cannot be easily identifiable. However, the committee has pointed out something worth noting, Right Honorable Speaker. The issue of what should be considered as a military attire to include the logo of the military. So if someone wears a cape that is merely red without a logo and serial number of the production or collection batch of the military, then those people should not be subject to this law. Then secondly, Right Honorable Speaker, the Supreme Court was very clear on the matter of civilians, and let me make it clear. At times, people travel with military personnel who are performing certain duties. At times, it's not official operations. And these people may make errors or may make omissions, but I'm in their company. It's not necessarily that it's adduced that I'm aiding and abetting the commission of this offense. However, when people are rounded up, they are rounded up in a group. So I would like to say, Right Honorable Speaker, that we maintain the position of the Supreme Court ruling and make it clear that we reject the trial of civilians in military courts. And therefore, I would like to move, Right Honorable Speaker, that we reject this clause in its entirety and uphold the position that you've passed in the earlier clause that is only military officers, and would like to recommit that those that are retired that are no longer serving. There is no order.
Thank
Which
you.
order?
Thank you.
We don't
Members, the
have
committee
moved that we
says
delete it.
the committee says we delete part C of the of clause 30.
Madam Chair, for me, I propose deleting the trial of civilians in a military court. Why is it? But the Honorable Tafire.
Honorable members, I put a question that clause 30 be amended as proposed by the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 30 as amended.
I put a question that clause 30 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 31.
I put a question that clause 31 of the bill stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Honorable Chair and colleagues, this is actually not a redundant provision. The provision says that a person will be subject will be a militant if subject to such exception, adaptations and modifications as the Defense Forces Council may by regulations prescribe. A person who under any arrangement is attached to any service or force of the Defense Forces or seconded as an officer or a militant outside the Defense Forces. Right Honorable Chair and colleagues, there could be a situation where the Defense Forces say, attach me, who is not in any of these categories. I'm not an employee, but say I'm a lawyer and I'm just attached to the Defense Forces to work with them on a particular assignment. And they make regulations for that purpose. While I'm there under those regulations, I will be subject to military law. So if you remove it, then you say I cannot be deployed there, which will be unfair and take me away my opportunity. So I propose, Right Honorable Chair and members, that this provision remain as it is.
I would like to strongly oppose and propose that this clause be deleted in its entirety, because the ruling of the Supreme Court was clear that by the operationalization of this, it is clearly unconstitutional. So I would like to move that the entire clause be deleted.
First read the clause before you say it is deleted.
The entire clause 29, and as it reads, that members of the Defense Forces subject to military law. I further re-echo that what we are talking about is subjecting people to the military court-martial that was considered unconstitutional by the ruling of the Supreme Court. So you can have your proposal. My proposal is that we delete it entirely. So move your proposal. Right Honorable Speaker, I move that we delete this entirely. But the Honorable Tafire is seconding me.
Honorable Medi,
I move that we delete the entire clause.
Honorable Medi, this is in relation to members of Defense Forces
Even
to be
that
subject to military law.
Even that one, I move that we delete this entirely. And the Honorable Tafire wants to second me.
Is it seconded?
Honorable Du is here seconding me.
Seconded by Honorable Du. Yes? You come to the microphone.
General, you are talking here about criminal law, criminal trial. The highest standard is needed before court. Industrial court, tax appeals tribunal, these are civil matters, and the burden of proof is on balance of probability. But here you are talking about criminal, yes, about issues of life and death. Somebody going to prison, somebody going to spend 6 months and etc. If we want to align with the decision of the court, for example, we could have only provided for one judge, like a chief magistrate, and don't bring these two who are not qualified. If we pass it like this, it will be easy for court still to nullify. How do I subject myself to a panel constituted of people who supposedly don't understand the law, who do not have qualification?
Honorable Attorney General, so you cannot have compare. So many lawyers in the army. Yeah.
Right Honorable, getting the purpose of this unit. We are talking about law experts in law. What about the experts in army business? What about experts in war? Because the unit court martial is not only dealing with matters.
Honorable Attorney General, there are soldiers who are lawyers.
Yes.
Chair, the expert, the Land Attorney General is talking an expert during a trial. You invite him as a witness to convince the one that is passing justice that this person is the expert you've presented. So which expert are you talking about? Because you should be talking about an expert in law, not an expert in military affairs. During a trial, if any side wants to present an expert, it seeks leave of court to present an expert to support its case.
Honorable Minister.
This is Honorable Medi is also a lawyer. And we practice criminal law in Uganda. We have assessors. Assessors are picked from the members of public. Now in this, because that's the temptation I try to say we should avoid. If we use the word assessors here, it would be like we are in a civil court. Now the political commissar has a specific duty. The administrative officer has of the unit where this officer must be there when they are trying his officer or her officer. So that is why they are there, but with one lawyer. But should it be the wisdom of this house that you want to remove them and you replace them with the lawyers? We have enough lawyers, but they were playing very core, critical administrative functions. They must give, in fact, not only that, there's an administrative officer of the unit, a political commissar of the unit, a regiment sergeant major. Now, this is where, when I am not surprised when Honorable Nsereko is asking me to do what. That's the real difference. I could have asked that question 4 years ago before I got to know about what the military does. These people are different. They are not the same. These people are very different. Let's help them.
Honorable members.
Yes.
Honorable
Madam Chair, the question I'm putting to my senior land council and honorable member is you're creating a jury here. And the issue you're saying is you're presenting experts in administration of justice under criminal law. But like you've said, you've clearly stated that the chairperson is well equipped with the tools of law, meaning the following will be his advisors. Therefore, if someone is being presented before an impartial
the following
court,
will be picked from B, the administrative officer of the unit.
Exactly.
The political commissar of the unit.
Exactly.
The sergeant and then the junior officer.
And Madam Chairperson, our argument is, if they are experts as the other side proposes, then let them come in as witnesses to support their case. No. Yes, because this is a court.
Tony.
You're not setting different rules.
Tony.
Thank you.
Why is General Jim Mwezi agitated?
Thank you
very much, Madam Chair. Madam Chair, the issue of elevation of this to a High Court judge, remember, High Court judges or an equivalent is not only subject to recommendation by the Judicial Service Commission, but also the Parliament of Uganda.
That is where? The chairperson of the division court?
The Parliament of Uganda, being an equivalent. The
Medi,
chairperson.
Medi, just a minute. The chairperson of the division court martial shall be an advocate of the High Court. You're saying a judge.
The amendment was saying something else. And what we are proposing, Right Honorable Chair, is that this continues to defy the orders of the Supreme Court. And our proposal is to move that the whole clause be deleted. And I move a motion that the clause be deleted. And Honorable Odur is seconding. Even Honorable Tafire.
Honorable Odur.
You will second.
Madam Chair, I have I have two issues here. The first one is the same as the concerns I raised about having two members in the panel, which under clause 8 says a panel constituted under subsection 7 shall hear and conclude the trial for which it was constituted, meaning still that two non-legal persons, as found already by court, will still sit there to determine a criminal matter. But the second issue that is important for us to reflect on here, Madam Chair, is that court, in arriving at the decision to declare the court-martial impartial, looked at the issue of tenure, security of tenure of the persons making this decision. The moment you say reappointed, you have already compromised my ability to deliver. I will deliver justice at the back of my mind, knowing that after 3 or 5 years, somebody else has control to appoint me. So it interferes. So what the Supreme Court had recommended was that the appointment of all the judicial officers under the provisions of the court-martial should be to the level as their counterparts who are in the civilian authority. That will ensure that if I am appointed a judge in the court-martial for that entire period until my retirement, I don't have to worry about the reappointment and the subject. So my submission is that as it is here, it does not address the concerns that was raised. These judicial officers here should be appointed in a manner that guarantees their security of tenure.
Do you want them to be permanent until retirement?
That's what the Supreme Court said, not me. That was the finding by Supreme Court, that if you appoint someone on a probationary, temporary, subject to something else, they cannot dispense justice. The impartiality and fairness required of them is clouded by their worry to be reappointed. So it is them to address it, but if they don't wish to address it,
thank you.
Madam, court-martial decision can be appealed to the Supreme Court where viewed as unfair. The bill restricts appeals on legal matters, making decisions of the chairperson of the unit and the division court-martial final. The committee deems this untenable as it prevents parties from challenging potentially erroneous legal decisions, risking miscarriages of justice. The bill's clauses on the appeal and enforcement of sentences, particularly regarding the death penalty, were also problematic. The phrase of notice of intention to appeal differs from a formal notice of appeal, creating ambiguity and risk that death sentences could be executed before appeals are determined, violating Article 22(1) of the Constitution. This article guarantees that no person shall be deprived of life except after a fair trial and confirmation by the highest appellate court. We therefore recommend, Right Honorable Speaker and Honorable colleagues, we recommend the following. 1, that appeals from the unit court-martials should lay with the division court-martial. 2, the decisions of a unit or division court-martial on matters of law and facts should be open to challenge. That appeals from decisions of the general court-martial should lay with the Court of Appeal as proposed in the bill. 4, proposed section 2272 should be deleted and section 2273 be aligned with the provisions of Article 221 of the Constitution. Structural reorganization of defense forces. The committee says vital role of Uganda People's Defense Forces that has played in upholding national security and preserving and defending sovereignty and territorial integrity of Uganda. In light of the evolving security threats and expanding military responsibilities, there is a critical need to realign the UPDF structure. Structural reform is based on Uganda's legal framework, specifically Article 2010 of the Constitution that empowers Parliament to make laws regulating Uganda People's Defence Forces, and in particular, provide for the organs and structures of UPDF. Section 2 of the UPDF Act, Cap 330, provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergencies. A significant advancement has been the emergence of Special Forces Command, a specialized allied unit tasked with carrying out specialized missions or operations at the moment's notice, very important persons, protection, and reconnaissance. While it is not legally provided for as a distinct service, the SFC holds a crucial position in linking conventional and special operations, collaborating closely with both land forces and air forces. The committee notes that the bill restructures the UPDF by creating new services such as the SFC and the reserve force to improve operational capacity and responsiveness. New organs such as the Joint Military Command and Service Command and staff committees are being established to enhance coordination, policy formulation, and strategic oversight. This reorganization also includes renaming and redefining roles in the command structure for clarity, for efficiency, and alignment with the current security needs. The committee therefore recommends that the proposal to restructure the UPDF to formally integrate specialized units such as the SFC as a distinct service branch should be supported to institutionalize specialized capabilities, enhance inter-service coordination, and ensure compliance with the legal and oversight requirements. On Veterans Affairs reforms, the committee notes that the bill proposes transferring administrative and management of pension and gratuity from the Ministry of Public Service to the Ministry of Defense and Veterans Affairs, aiming to enhance service delivery and more effectively to meet the needs of the military personnel. A key aspect of this reform is the establishment of the Pensions Appeals Board to provide a formal mechanism for addressing grievances and disputes related to pension matters. Additionally, the repeal of the Uganda Veterans Assistance Board Act Cap 221 signifies a shift towards a more integrated and updated legal framework. These reforms also introduce comprehensive provisions for retirement benefits, gratuity, and pensions, including entitlements related to death in service and disability, ensuring improved welfare and dignity for the serving personnel and the veterans alike. The Kampala reduction in force UPDF veterans informed the committee that although they voluntarily enlisted in the National Resistance Army struggle, which ultimately resulted in a change of government, they continued to serve in the NRM UPDF until their discharge, which occurred without a proper and formal dismissal. The committee notes that the UPDF has transformed since the 1990s, following significant military downsizing after achieving stability post-internal conflict. This began demobilization efforts, and restructuring of the UPDF alongside pension reforms for veterans. The reduction in force affected thousands of personnel, especially older veterans and non-combatants, aimed at enhancing security and lowering public spending. However, systemic issues in the pension system emerged as many veterans faced unclear entitlements, delays, and bureaucratic hurdles in obtaining their benefits. Scholars such as Obore in 2006 highlight that while legislation aimed to guarantee pension rights, many veterans remain unrecognized due to inadequate documentation or unclear classifications, e.g., informal service or voluntarism, not recognized as pensionable. Thus, the committee believes that while the bill will strengthen the pension and gratuity administration for the UPDF veterans, actual realization of the rights remains uneven for the demobilized veterans. Additionally, the bill currently excludes individuals or militants who retired before its enactment, which lacks a commencement date. Its provisions have no retrospective effect and do not address retired officers and militants. Right Honorable Speaker and Honorable colleagues, we therefore recommend, 1, that decentralization of the pension authority to the Ministry of Defense and Veteran Affairs as proposed in the bill should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike. Welfare and health services. The committee observes that the bill proposes establishing a health care service.
Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here is it in order for them to continue defying the ruling that you made that this front seat be reserved for the members? Is it in order?
Honorable